market-neutral strategies.
My Lords, I appear together with Mr Alatoff, the appellant, my learned friends Mr Chivers, Mr Smith and Mr Hobden appear for the respondent. As your Lordships will have seen, the issues in the appeal concern firstly the sources from which a company can make payments to its shareholders by way of the redemption or repurchase of the shares of those shareholders and the conditions which attach to the use of those sources. Secondly, whether those conditions were satisfied in the present case in relation to the payments made to the respondent in respect to the redemption of the shares held by it. And then finally, if the conditions weren't satisfied, whether there's any right to recover the payments by way of an action in restitution. Now, my Lords, the courts below held that the redemption payments made to the respondent in the present case were made from a permitted source. In particular, they held that the company was entitled to use funds standing to the credit of its share premium account to make the redemption payments, and that it was entitled to do that even where the company was insolvent and unable to pay its other creditors in full. Now, my Lords, we say, firstly, that would be an odd result, because it would mean that shareholders could have recourse to the share premium account even where creditors aren't in a position to be paid in full. But we also say it's based on a clear misreading of the Cayman legislation, since the relevant condition, which is now in section 73(3)(f) of the 2007 revision of the Companies Law.
73?
37(3)(f). And that's the relevant provision which applies in terms permit shares to be redeemed from funds standing to the credit of the share premium account, and it only permitted such payments to be made from the company's assets, generally to the extent that it was solvent. And your Lordships will see section 37 behind divider 4 of the first authorities bundles, E566.
So you say F applies due to what? To the whole amount of any sum required on a redemption, including the premium?
Yes, we do.
I mean, that's odd, because on the face of it, E is dealing with the premium, and one would assume, therefore, that F is dealing probably with a nominal value. The premium payable on redemption, in other words, is distinct from the amounts in respect to which or by which you redeem.
Well, my Lord, I'll show you why we say it applies to both by reference to the history of the legislation.
There is a sort of crucial difference between you on that point.
There is, yes.
Whether you can split up the share in some way between the nominal amount.
I mean, if, assuming the analysis I put and my Lord's mentioned to you is correct, it still doesn't solve the problem that on Mr. Chivers' analysis, somehow you can have a valid redemption even though part of it is invalid.
Well, that's right. And my Lord, I think in substance there's really two limbs to our argument, which is firstly we say F applies to the whole shares, including the premium and the nominal amount. But even if we're wrong about that and you read F as just applying to the nominal amount, you still need to satisfy both E and F in order to have a valid redemption payment.
Yes. The two separate parts, the premium payable on and the...
And it makes no... Yeah, and it makes no sense to have a situation where you have a valid payment of premium, but an invalid payment of the nominal amount. And in our submission, that would be...
Hard to see how logically you could cancel the shares.
Exactly. And the premium is the premium on the nominal amount. I mean, the two go hand in hand. It's simply that part of the purchase price, yes, which is in excess of the nominal amount.
Because if you go to 32(2)(f), you see that it says there that the share premium account may be applied for providing the premium payable on redemption.
Sorry, 32?
2F. 34(2)(f). 34(2)(f),
yeah.
Yes.
Right.
If you can't redeem the nominal amount, where does it take you?
Exactly. So, I mean, ultimately, we say the two go hand in hand. You had to satisfy both the conditions, and I'll show your Lordships in due course some of the extracts from Palmer, for example.
I mean, historically, they're quite different, so that one can understand why there should be a distinction in this legislation, because historically, the amount of the premium was just treated as profit, and then eventually, in English law, it became quasi-capital.
Yes.
query to the extent to which it's quite become quasi-capital in Cayman, but anyway, they are different.
They are, absolutely, and your Lordship's exactly right, and that all goes to the history of the share premium again. But what I was going to show you, your Lordship, which seems to us to be most illuminating, is the 1929 Act, when this condition was first introduced, and when I think one can see, with some degree of clarity, what it was aimed to deal with and how it worked. But I'm going to come to that. But I mean, your Lordships obviously appreciate the ways in which we put the argument.
Yes.
I mean, we obviously may have to consider the English history, but it may, I think, part of the case against you is that the Cayman legislation has differed as it has, and that things may have changed in the Cayman. One way they will certainly change if this appeal were to succeed is one would have thought by creating a complete chaos. So you're going to have to address that. Your cases are remarkably, or your cases are very silent on that point, and I think although it's in a sense the tail which comes at the end, we're going to be interested to some extent in that.
You mean in terms of the ability
Well, I
to
mean, if
cover
this were a
payments?
Madoff type master fund rather than apparently a one-off short-term fraud in 2008,
Yes.
the consequence of your case would be what?
Well,
to unravel all payments made out in the last decades?
Well, no, because a very important point to bear in mind is the test here is based on cash flow insolvency, not balance sheet insolvency. So the solvency test would kick in where the company is in fact unable to pay its debts as and when they fall due in a cash flow sense. And in our submission, that is something that the directors of a fund, almost by definition, are likely to know. And it's not going to apply to a Madoff fund to the extent it actually had cash available to it and was able to make the redemptions in and out. It's going to apply to the situation where debts were due, but the company did not in fact have enough cash to meet them. And the present case, in fact, is a paradigm example of that, because what you had was a number of redemption debts which all fell due on the same redemption day. There were other creditors as well. The company didn't have enough to pay all the redemption creditors. It paid some in part, some in full, some got nothing at all. That is a paradigm situation of cash flow insolvency. The company was clearly in a position not to meet all its debts as a matter of cash flow as they fell due. And it's in that circumstance where the right to recover in our submission kicks in. Now,
I mean, does this mean that if you take, roughly speaking, the Madoff facts, where from a certain point, I think around 1996, there were no assets at all. All that happened was that completely fictitious lists of alleged investments were sent out as representing people's portfolios, and the outfit was funded entirely from incoming investments.
Yes.
So your submission is that that would have satisfied the solvency test.
Yes, we're not seeking to undo the NAVs, which are binding as a matter of the articles at which investors redeem their shares. The NAVs are binding. The fact that now, with the benefit of hindsight, all being seen to be based on fictitious profits is besides the point. They're binding under the articles. What we're concerned with is a situation like the present, where there are debts of the company, including those arising as a result of redemption requests. The company doesn't have enough cash.
Well, there are no fresh investments coming in.
Yes, there's no cash to meet all the debts which have fallen due.
So you can be, I mean, we're talking about the cash flow solvency of the feeder fund, are we?
We are, in this particular case.
So
yes.
a feeder fund can be regarded as cash flow solvent, can it, when it's receiving from a Madoff master fund?
We're receiving from the investors.
Well,
New investors.
I see it's receiving from its, well,
Or from a leverage provider. I mean, it may have access to leverage, or a liquidity facility, which gives it cash to meet
but
its
it's only receiving.
Sort of jumping ahead of ourselves.
Yes.
We are.
Yes.
I mean, I'd quite like to see, where the argument is going, and then obviously the consequence becomes...
Yes, we are.
The point that you just made, does that not to some extent undermine your big picture point that the result is odd? Because if the result can be achieved anyway, because the company, although balance sheet insolvent, is cash flow solvent, one may have to take the view that the oddity just doesn't enter into it. It's all...
Well, I mean, in our submission, the particular oddity which arises in this case is where you've got a number of debts which have accrued due, and in fact all fallen due at the same date, and the company has a limited pool of cash. It doesn't have enough cash to pay all those debts. It would be odd if the company could legitimately, through the device of the share premium account, pay some of those creditors in full and give other creditors nothing.
It would be equally odd if, because it was balance sheet insolvent, the duty of the directors was to put it into liquidation forthwith.
Well, yes, but I mean, obviously the directors don't, so far as that balance sheet insolvency is concerned, they don't know that at the time, and obviously they're proceeding on the basis of the NAV. And the approach, obviously, which the courts have taken to that, including this court, is to say, well, if the NAVs are binding as a matter of the articles, they are binding, and that's
what we decided in Fairfield Century.
Exactly. But I mean, as you say...
Right. Now let's allow you to get on with it.
That's the third issue, and I'll come to it, hopefully, having navigated the first two issues. I mean, as we say, just to complete the overview, I mean, we say the redemption payments made to the respondents in the present case were unlawful, and that's the effect of the statute, and that there is a right to recover those payments. And the effect of that, in this case, is that the payments would be returned to the company in liquidation. The respondent would then share pari passu in the monies as a creditor alongside the other redeemed investors, and after the ordinary unsecured creditors had been paid in full. Now, for the purpose of these submissions, I was proposing to address four topics. Firstly, the development of the restrictions imposed under the company's legislation on the sources from which a company could redeem or repurchase its own shares. And I obviously bear in mind, ultimately, we're dealing with a Cayman statute here. It is in my submission helpful to look at the earlier legislation to gain some understanding of how the same provisions worked. Secondly, the proper construction of the relevant provisions of the Companies Law 2007. Thirdly, the question of whether DD Growth was at the relevant time able to pay its debts as they fell due in the ordinary course of business. And that goes to the question of whether or not DD Growth was able to make the redemption payments from its ordinary assets pursuant to Section 37.5. And fourthly, and finally, the question of remedy, and whether if the redemption payments made to the respondent were unlawful, there's a right to restitution of those payments.
Presumably, the third question, DD had assets of two sorts, potentially, further investments in it,
yes,
and payments out by the master fund.
Yes.
Yeah. So if either of those fails, it may become cash flow insolvent.
Yes.
Yeah. And the former, the payments, investments, are likely to depend on whether the master fund is paying, presumably, or can pay.
And I mean, just by elaboration on that, it's common ground that the company was cash flow insolvent if you take its redemption debts into account. The issue between the parties on this point is whether you take the redemption debts into account for the purposes of determining solvency. That's the issue. It's common ground, as the courts below found, that if you do take redemption debts into account, it was cash flow insolvent.
It's, I think, common ground that it's a debt. As I understand it, the issue is whether it's a debt payable in the ordinary course of business.
Yes, that's exactly right.
Yes.
There's that contention as to whether that places a gloss on the type of debt you take into account for the purposes of the test. So, my lords, dealing then with the first topic, which is the restrictions under the company's legislation on the sources from which a company can fund the redemption and repurchase of its own shares. Simply by way of recap, the starting point in our submission is the well-known common law rule that the distribution of a company's assets to a shareholder, which amounts to a return of capital, is unlawful, except to the extent that it's permitted by statute. And that's the well-known rule. It was restated by the Supreme Court in the Progress Property against Moore case by Lord Walker. at paragraph 15. I don't think we need to turn it up. It traces its origins back to the well-known decision in Trevor and Whitworth.
Well, it's paragraph 20 of your case, isn't it?
It is, my lord, I think, yes. Now, my lord, the basic position, therefore, is that any distribution of property to a shareholder amounting to a return of capital is unlawful unless permitted by the statute. Now, clearly, the statute does permit a return of capital in a number of different ways, and there are statutory procedures enabling assets to be returned to shareholders. And one of those procedures is the ability conferred on a company under the company's legislation to redeem or repurchase its own ways. That's one of the statutory permissions, statutory permitted ways in which capital can be returned. Now, the ability given to a company to redeem shares was first introduced by the Companies Act 1929, which permitted a company to issue and redeem preference shares. But, and this is the key point in our submission, this ability to redeem has always been subject to restrictions and safeguards designed to protect the position of creditors of the company, including in particular as to the sources from which any redemption could be funded. Now, if I could take your lordships to the 1929 Act, which your lordships will find behind Divider 7, Bundle 1. The relevant provision is section 46, which is at page 589 of the e-bundle.
46.
Section 46, yes, my lord. And this introduced for the first time the power given to the company to issue preference shares which were redeemable. Now, your lordships will see that that power was subject to 4 provisos which were set out in A to D of section 46, subsection 1. The first of which is no shares shall be redeemed except out of profits, which would otherwise be available for dividends, or out of the proceeds of a fresh issue of shares made for the purposes of the redemption. And that, subject to some drafting changes, is the forebear of section 37(3)(f). B, no shares shall be redeemed unless they're fully paid. C dealt with something called the capital redemption reserve, where shares were redeemed out of profits. And then D...
That's to stop the reduction of capital, effectively.
Exactly. So where you redeem out of profits, in order to stop the capital being diminished, the company had to create a capital redemption reserve, which is quite similar in some ways to the share premium account. It's a statutory fund form of quasi-capital. And then, obviously, for our purposes also of relevance is D, which your lordship will see comes at the end, and provided that where any shares are redeemed out of the proceeds of a fresh issue, the premium, if any, payable on redemption must have been provided for out of the profits of the company before the shares are redeemed. Now, as I say, although there's been some additions to the drafting, each of those conditions remains in section 37 of the 2007 revision of the Companies Law. And as I said, our case is essentially based on the successor provision to section 46(1)(a), which is now section 37(3)(f). Now, the important point for present purposes is that it was in our submission clear that these provisions were cumulative, in the sense that each proviso had to be satisfied where it applied by its terms. And obviously that's the case if you look, for example, at B. I mean, clearly it's not sufficient to satisfy B by itself. You have to satisfy each of the provisos where they apply by their terms. Now,
what's also clear is, going back to practically the first point we mentioned this morning, is that D distinguishes the premium payable on redemption from the actual redemption, doesn't it? Contrary to your case, although it may not be essential to your case.
Well, I'm not sure it does with respect. I mean, let me just give an example to try and illustrate that, because in our submission, what D is aimed at is where you're raising capital from a fresh issue and using that to fund the redemption. And what it's aimed at stopping you from doing as the company is using capital raised on a fresh issue to fund the premium due on a redemption, if your lordships follow. It's designed, so if, for example, and perhaps I can give your lordships an example just to illustrate the point. I mean, let's take an example where one has 1,000 shares of £1 each being redeemed at a premium of £1 each. So you need total redemption proceeds of 2,000. If you're going to fund that from the fresh issue, you need to raise £2,000 by way of a fresh issue. That's the cash sum you need. But what you can't do is simply use that 2,000 by way of capital to fund the premium due on a redemption of shares. What you need in addition to the £2,000 of new capital is £1,000 standing to the credit of your share premium account.
Well, that's what your case is, but I don't understand why it follows. Why isn't it dealing with the situation where you redeem the shares which have a nominal value of £1,000 by a fresh issue, raising £1,000, and then, insofar as there's premium payable, you have to take that out of the profits? Why, in other words, why do you need to effectively cover £3,000 to pay off £2,000?
Well, you don't need to cover £3,000 to pay off £2,000, but it's dealing with the situation where you're redeeming shares at a premium. And the example I've given is you're redeeming shares of a nominal amount of £1,000 of a premium. You're doing that from the proceeds of a fresh issue. If you simply raise £2,000 by way of nominal amount on the fresh issue, absent D, you would be entitled to use capital to redeem premium. And the purpose of D is to stop you doing that. It's basically to say, well, if you're going to raise it by way of a fresh issue, you can do that. But insofar as you're redeeming as to premium, that needs to come from profit, if your lordships follow. It's effectively, in our submission, imposing a rider.
I mean, the trouble with that, I don't understand myself at the moment how at the same time you can be covering the premium by the fresh issue and covering it out of profits. It must come from one or other. It can't come from both at the same time. It's only £1,000.
No, it doesn't. But it's, I mean, how it would work in our submission, to go back to my example, you've got 1,000 shares of £1 each being redeemed at a premium of £1 each. You need to pay out £2,000, £1,000 as to profit, £1,000 as to premium. The £2,000, what you can't do in order to fund the £2,000 is simply raise that solely from the proceeds of a fresh issue. But your lordship's right. I mean, we're not saying you need £3,000. All you need is, in that situation, is to have at least £1,000 of profit in order to fund the premium. What it's basically doing is stopping you using the nominal amount raised on a fresh issue in order to fund premium due on a redemption.
So to that extent, half the nominal amount which you raise on the fresh issue is irrelevant to the redemption or the premium payable on redemption, it seems to me.
That's right, yes.
Yeah. So,
absolutely,
okay.
yes.
So, in fact, you could just raise £1,000 by the fresh issue, and
you could.
Yes, I see. So
you could
cover the premium out of profits.
Yes, exactly. Yes. But it seems to us it's important to see how it works, in the sense that what it's doing is imposing a rider or restriction on your ability to redeem out of the proceeds of a fresh issue. And it seems that the purpose of this originally was to stop premium due on a redemption being funded from capital raised on a fresh issue.
Yes. So you say, as far as relevant, you read A and D cumulatively.
Yes.
If A were there alone, then the proceeds of the fresh issue could be used for the whole redemption, but A and D prevents it.
Exactly. I mean, that's exactly the point. And obviously, when one looks at items like B as well, I mean, it becomes even more obvious that all of these are cumulative in effect.
The draftsman here is not thinking, Chef, about redeeming shares out of an original premium account created on the issue of those redeemable shares, because he's thinking of redeemable preference shares, and
yes,
most unlikely they'll be issued at a premium.
Yes.
Yeah.
Exactly. So, as we say, just looking at that, and one sees the original drafting in its original form, and in our submission, it is clear at that stage that these were a set of conditions were effectively cumulative in the sense that each had to be satisfied where it applied. Now, one then gets the 1948 Companies Act, which is behind divider 8, the following tab. And the relevant section now becomes section 58, which is at page 595 of the e-bundle. And your lordships will see it's in broadly the same terms as section 46 we were just looking at. For some reason, the order of C and D has now been reversed. But the more substantive change is that within C, there's now a reference to the share premium account. So it now says the premium can be provided for either out of profits or out of the share premium account. And as your lords will have seen from our written case, the share premium account was a new feature introduced in the 1948 Companies Act for the first time. We've explained the background to its introduction in our written case at paragraphs 22 to 29. In very short summary, prior to the 1948 Act, where a company issued shares at a premium to their nominal value, then the premium was technically profit, not capital, and could be distributed to shareholders. It seems that although that was the legal position, over time, creditors had in practice come to regard the premium as being more akin to capital than profit, and then there was therefore some surprise, it appears, when in a case called Drown, in 1937, the courts had effectively affirmed the orthodox position and said that premium was not capital, it could be distributed to shareholders and profit. And then that decision in Drown was then reversed, in effect, in the 1948 Act, which introduced the concept of a share premium account. And the share premium account wasn't share capital as such, but under the legislation it was to be treated as if share capital. And your lordship sees that just back a couple of pages in section 56 of the 1948 Act, which introduced the share premium account, where a company issues shares at a premium, whether for cash or otherwise, a sum equal to the aggregate amount or value of the premiums is to be transferred to the share premium account, and then it's effectively treated as if it was share capital, and hence it's sometimes referred to as quasi-capital. The legislation uses the words as if. But then your lordships will see, importantly in subsection 2, from the outset there have been permitted uses of the share premium account, including there in A, paying off preliminary expenses, and then expenses relating to the issue of shares or debentures, and then, importantly for our purposes, in the bit that follows, or in providing for premium payable on redemption of any redeemable preference shares or any debentures of the company. And that's what became section 34 2F. And in our submission, that fits with the change which they'd made to section 58.1c. The two fit together, hand in glove, because 58.1c now says, well, you can provide for the premium out of the share premium account, and that fits exactly with the permission given in 34.2. Now, just to leap ahead, one of the problems we say with the Court of Appeal's approach is that they treated that language in what was section 56.2 in effect as providing for a freestanding gateway for the payment of the premium. They said, well, that says you can provide for the premium. That means you can pay the premium no matter what. In our submission, that was an incorrect approach, because all that is doing is effectively providing for the permission in relation to the use of the account, but the conditions governing redemption and the ability to make the redemption payment were all set out in section 58. And effectively what section 56 was doing was providing the permission to use the share premium account in the manner which was envisaged by section 58(1)(c). Now, just going back to section 58, again, key point for our purposes is that the conditions in A to D all had to be satisfied where they applied. And I can show you, your lordships, a couple of sources which in our submission support that proposition. The first is Palmer, which is in the third authorities bundle behind divider 63. So this is the 22nd edition from 1976, but it's dealing with the 1948 Companies Act. And the relevant section is at paragraph 35-19. Redemption is only possible if the statutory conditions for redemption are satisfied and if the redemption is effected upon such terms and in such manner as the articles provide. The statutory conditions for redemption of preference shares are, and then 1, 2, 3, 4, and in our submission, clearly treating those as cumulative, as applying generally to the redemption as a single process, as it were. I mean, there's no suggestion anywhere that somehow the provision in relation to premium applies separately so that one can validly make a redemption payment as to premium, even if the conditions applying to the redemption of the nominal amount aren't satisfied. And, my Lord, the other source, which is in our submission helpful on this point, is the government's own consultation paper behind divider 64, which was produced prior to amendments which were made in the Companies Act 1981, which widened the ability of a company to redeem or repurchase its own shares. And this was produced by Professor Gower. And there's a very long and learned description of the background, which one sees beginning on page 1748. And in particular, if we pick it up at paragraph 3.
Wait, which paragraph?
Paragraph 3 on page 1748. This is a section of the paper dealing with the present legal position, in other words, prior to the amendments envisaged in the 1981 Act. He refers in paragraph 1 to Trevor and Whitworth. And then in paragraph 3, of the exceptions listed in paragraph 1 to the general principle, that relating to redeemable preference shares is by far the most important and also the most interesting in the present context. It shows that it's possible to provide for repurchase of shares in a way which does not impair capital to the detriment of creditors. Then he refers to section 58, replacing the provision of the 1929 Act. And then if you just pick it up towards the bottom of that page, but they may be redeemed only if fully paid and only out of profits which would otherwise be available for dividend or out of the proceeds of a fresh issue made for the purposes of redemption. In either case, any premium payable on redemption must be provided for out of profits. And under the amendment in the 1988, expressing profits which would otherwise be available for dividend or out of the share premium account. So all of this is treated as cumulative, and in particular, the proviso relating to the use of premium is something which applies in addition to the other conditions. And there's no suggestion, again, that somehow you can play the premium validly in circumstances where the other conditions aren't satisfied, and in particular where the condition as to the paying off the nominal amount isn't satisfied. So, Miller, that's the background, which we say it is helpful to look at how this legislation had its genesis in the 29 Act and the 1948 Act. We then come to the second of my topics, which is the position in the Cayman Islands. Now, the position there is that the 1963 Companies Law basically mirrored, almost word for word, the 1948 Companies Act. There are some minor differences, but basically it was the same, and it contained a Section 32 and a Section 34, which were in essentially the same terms as Section 56 and 58 of the Companies Act. So the starting position in the 1963 Companies Law is exactly as I showed your lordships in the Companies Act 1948. Now, the first set of critical changes for our purposes were those then made in the 1987 Cayman Companies Law. And that made two relevant changes. The first was it permitted any kind of shares to be redeemed or repurchased. So the power was no longer limited to the redemption of preference shares. Much like the English legislation done in 1981, basically you could now redeem any kind of shares, and you could now repurchase shares as well, and repurchase any kind of shares. And then the second change was that in addition to redeeming or repurchasing shares from profits or the proceeds of a fresh issue, a company could now redeem or repurchase shares from any of its assets, but only provided that a solvency test was satisfied. Now, those changes were reflected in a revised version of Section 34 of the Companies Law, which your lordships will find behind Divider 2 of Authorities Bundle 1. And this is this operated by substituting in a new Section 34, although as you'll see in a moment, a number of the provisions are basically the same as those in the predecessor legislation. Subparagraphs 1 and 2, I think we can skip over. Those basically give the power and the permission to issue and repurchase redeemable shares. And then subsection 3 is of relevance for our purposes because that sets out the provisions governing redemption or repurchase. And as you'll see, those follow closely those which had been contained in Section 58 of the 1948 Act. So under A, no share may be redeemed or purchased unless it's fully paid. There's then a new requirement in B that there must be, you can't have a position transpiring where there's no other member holding shares. C, redemption of shares may be effected in such manner as may be authorised by or pursuant to the company's Articles of Association, which corresponds to Section 58(2) of the 1948 Companies Act. D is new, but then E and F are basically following the provisions which we've already seen, which are in Section 58(1)(c) and 58(1)(a) of the Companies Act. Now, for some reason, the order of the provisions has been changed in a way that might not be entirely helpful, because the provision dealing with the premium now comes before subsection F. Whereas it seems to us, actually, the draftsman's original logic of having them the other way round made more sense. But be that as it may, that change has been made. But basically, the provisions remained. And in our submission, those were cumulative, as they always had been. So in other words, under F, subject to what was in subsection 5, which we'll come to, the shares had to be redeemed or purchased out of profits or out of the proceeds of a fresh issue. And under E, to the extent there's any premium payable on redemption, that has to come come out of either profits or the share premium account. And basically, this is following the same structure of the 1948 Act, which originally owes its genesis to the 1929 Act. Now, the change in F, your Lordships will see that there's some wording which was added to the very beginning of F, which says subject to the provisions of subsection 5. And it's that which introduced the ability of the company to fund the redemption or the repurchase from its assets generally. But as I will show your Lordships in a minute, that has always been subject to the satisfaction of a solvency test. And your Lordships see subsection 5 over the page at 555H. One starts in A.
5H.
555H, yes. So this is subsection 5.
All right, mine's,
There isn't an H.
it stops at F in my 12.
Mine has an H.
Are we talking about an amendment in 1989, perhaps?
No, it's these pages were missing from the authorities bundle originally. I had them added, but obviously it hasn't made its way through.
You're talking about the page, not the section.
Oh, yeah.
Yes.
555H.
Oh, well, that's fine. Yes.
Right.
Oh, sorry, yes, yes, I do apologise. Yes, I'm talking about the page number 555H.
Right.
And then the section is section 34, 5A.
Yes.
And, well, as that introduced the ability to fund the redemption or the repurchase from assets generally, in other words, otherwise than out of profits or the proceeds of a fresh issue of shares. B is a sort of deeming provision which refers to that type of payment as a payment out of capital. And that's the language that is used in the remainder of the subsection.
Just tell me why it wouldn't be regarded, I mean, why was B necessary as a matter of interest? If it's not out of profits or the proceeds of a fresh issue of shares, wouldn't it normally be regarded as being out of capital?
It would, yes.
Yes.
It would.
So
I mean, I suspect...
B, for some reason, is necessary to provide that...
Well, I think it's probably just for the reasons of adding clarity to the remainder of the subsection. It sort of operates like a definition provision almost, because...
Well, there had been a certain amount of debate about whether it was capital, had there not?
About whether...
About whether it was capital.
what was
well, I suppose if your Lordship... I mean, I see your Lordship's point. I mean, to the extent subsection 5 is covering a payment which might be covered by the share premium account.
Yes.
I can see your Lordship's point because...
I mean, that question was resolved by case law, but
yes.
It was, until then, it had not been entirely clear.
Exactly, and ultimately it has this sort of... Share premium account always had this slightly grey status of quasi-capital in any event.
But the difficulty about that is that you don't actually need subsection 5 to deal with share premium account because you've already provided in section 34(3)(e) for payment of the premium out of the share premium account.
So far as the premium is concerned, yes. Not so far as the nominal amount is concerned.
Nobody's suggesting you can use the share premium account to cover the nominal amount, are you? Or can you under subsection 5?
Well, you can, provided the solvency test is satisfied, yes.
Yes, I see. Yes, okay.
Which is the key point. So one's got 5A and B, which, if you like, give you the general permission. But then what's of critical importance for our purposes is on the next page, 6A, and then 6B, because 6A makes a payment out of capital, which we've seen defined, by a company for the redemption or purchase of its own shares as being not lawful unless immediately following the date on which the payment is proposed to be made, the company shall be able to pay its debts as they fall due in the ordinary course of business. And we'll come back to debating what the effect is of the words in the ordinary course of business. But the basic point is that there was, in 1987, this ability introduced to fund the redemption from sources other than the profits or the proceeds of a fresh issue, but it was subject very specifically to the solvency test being satisfied. And if the solvency test wasn't satisfied, then the payment would be unlawful. So those really are the principal changes that took place in 1987, and as I'll show you, that really remains the architecture of the Act when one gets to the 2007 version, which is the relevant version for our purposes. The other relevant change that I need to draw to your Lordship's attention occurred in 1989. And those provisions, your Lordship will find behind Divider 3. And at this point, certain changes were made to the company's law, widening the permitted use of the share premium account. And in particular, a permission was given to use the share premium account to make distributions or pay dividends to members, which was a new development, but again, only provided that a solvency test was satisfied. And in effect, what happened was they widened the permitted uses. You could use it to make distributions to members, but the quid pro quo for the extension of that permission was that the solvency test had to be satisfied. And that was introduced by a new subsection, section 32, which your Lordships will see at page 557. And you'll see subsection 2. The share premium account may be applied by the company, subject to what its memorandum or articles of association say, in such manner as the company may from time to time determine, including but without limitation, paying distributions or dividends to members. So that is new. And B deals with paying up unissued shares. C, in the manner provided in section 34, which no doubt reflects the fact that under section 37(5), you could now use the company's assets generally for the purposes of funding redemptions or repurchases, but subject to satisfying the solvency test in section 37(6)(a). And then D, E, and F, effectively the continuing provisions which we'd seen in the 1948 Act. And then...
Sorry, in the 48 Act? Oh.
Yes, it was section 56 of the 1948 Act.
Yes.
And then what's obviously important is the language one sees immediately following subsection F, provided that no distribution or dividend may be paid to members out of the share premium account unless immediately following the date on which the distribution or dividends is proposed to be paid, the company shall be able to pay its debts as they fall due in the ordinary course of business. It's picking up basically the same language the draftsman had used for the solvency test in section 37(6)(a). But your Lordships, in our submission, can see what has happened here, which is that there has been a widening of the permitted uses of the share premium account. Its position as quasi-capital or as if capital has changed, but the quid pro quo for that change is that if you're going to pay members by way of distribution or dividend, you can only do so if the solvency test is satisfied.
But the proviso, do you accept, applies to A, the distribution or dividends, not
Yes.
to the others?
That's right, but so far as C is concerned, well, you've got the solvency test there anyway in section 37(6)(a). And F, we say, well, that isn't an independent gateway allowing payment of the premium. That's the provision that's always been there in the Companies Act since, in fact, 1948, which is simply permitting the use in the manner which has always been contemplated.
So you needed the proviso because you were introducing a new
Exactly.
way of paying, which was distribution or dividends.
As worded in the opening words of subsection 2, it is saying, subject to the articles, you can use the share premium account in any way, A to F being without limitation.
Yes.
And but the only thing on which the proviso bites is A.
That's right. That's
But
right.
isn't that... Is it therefore difficult to regard a premium payable on redemption as subject to the proviso, as being a distribution within A, at the same time as being within F?
The way we would put our case is to say, so far as using the share premium account for the redemption of shares is concerned, that is subject to 37.5 and 37.6. And when one gets, for example, and the way one gets into that is through C, which says you can use it in the manner provided in section 34, which is now...
Sorry, you say subject to section 37?
Yes, so it's section 34 of this version of the law. It subsequently became section 37.
This act, yes.
But what one gets in C is it does say you can use the share premium account in the manner provided in section 34. But so far as section 34 is concerned, if you're using the share premium account to redeem nominal amount, you're within section 34.3f, which takes you to section 34.5 and then to section 34.6a. So the solvency test kicks in there. And that isn't surprising because if one takes a step back, I mean, the policy here behind these changes was obviously to say, well, you can use the share premium account to pay your members, but only if you're solvent. I mean, that seems to be the underlying policy principle behind certainly A. And it was entirely consistent with that to be only able to use the share premium account for redemptions if the company is insolvent. One then gets the symmetry. It would be slightly odd, we'd suggest, if in 1989 the legislature had said you can use the share premium account to pay your members, but only if you're solvent, but at the same time had said, well, you can do it by way of redemption of the shares, even if you're not solvent. I mean, it's difficult to see why there would have been that sort of dichotomy. And in our submission, no policy reason for that, and the answer as a matter of construction of the legislation is quite straightforward. But it is, the reason I show you that is, it's clearly relevant, but it's also relevant, I think, in highlighting the general policy approach which has been taken in the Cayman Islands to the use of the share premium account so far as members are concerned. Now, having trailed through that background, we then get to what really matters, which is the 2007 law behind Divider 4. And this is basically in the same terms as the legislation we've just been looking at, in other words, as it stood in 1989. Page 563, what had been section 32 has now become section 34. But other than that, it's the same. And over on page 565, section 34 has now become section 37. But that is basically in the same terms as it stood in 1989 as well. And one sees, in particular, within subsection 3, paragraphs E and F. And as I say, F as it stands is essentially the same condition as it first appeared in section 46(1)A of the 1929 Companies Act, subject to the additional reference to subsection 5. Now, just pausing there, in our submission, our case, we hope is essentially a straightforward one. We simply say that section 37(3)F required the redemption payments to the respondent, certainly by way of nominal amount of the shares, to be funded from one or more of the three sources specified in that section. Basically 3 choices. Those are profits, proceeds of a fresh issue, or in the manner provided for in subsection 5. So you've got the 3 options. Now, as to those, we can take profits off the table very quickly because there were no distributable profits at the relevant time. That is common ground. It's in the Statement of Facts and Issues, paragraph 15. So we can leave profits to one side. There was no fresh issue of shares, obviously. There was no investors coming in at this stage subscribing for new shares. So that is off the table as well, which leaves subsection 5. Now, so far as subsection 5 is concerned, the solvency test was not satisfied because DD Growth was insolvent at the relevant time. The test in section 37(6)(a) was not satisfied. DD Growth was insolvent. That is what the Grand Court found. It's disputed by the respondent on the basis they say, well, they only found it was insolvent taking redemption debts into account, and they say that's wrong. We'll come back to that as my third topic. But assuming we are right that the solvency test applicable to section 37(5) was not satisfied, then the payments made by way of redemption from the company's assets were in our submission unlawful pursuant to section 37(6)(a). Now, turning for a moment to the approach which the Court of Appeal took, in our submission, the Court of Appeal in its judgment failed to deal with the central issue of how the redemption payments made in the present case were funded from one or more of the permitted sources allowed by section 37(3)(f). And there were 2 critical errors in our submission in the Court of Appeal's analysis of section 37(3)(f). The first is an error simply in the language of the provision which they were looking at and which unfortunately has carried its way through to some of the analysis. And secondly, there was what was in our submission a misconception in understanding the interrelationship between section 37(3)(e) and F. Now, if I can invite your lordships just to turn to the Court of Appeal's judgment for a moment, which is in the record behind slide 2. If your lordships go immediately to paragraph 33, on page 14 of the record, your lordships will see the Court of Appeal there begins its consideration of section 37 of the law, obviously the key provision, and a number of subsections that are set out there. Now, just looking on page 15 at E and F, E is correctly recorded as being E as it stood in the 2007 version of the Companies Law. F, however, is for some reason not the version of F as it stood in the 2007 Companies Law. It's the version which was subsequently amended for the 2011 law. And there's 2 critical changes. Firstly, the word only, which appears after may, was deleted. So one needs to write in the word only after may. But then, perhaps more importantly, the words which one sees here, out of the share premium account, were new. Those do not appear in the 2007 version of the law. That was an amendment made later. Now, mean, it's slightly curious. I didn't appear below. I don't know how this error was made because it's odd because E actually is correctly stated from the 2007 law. The problem is just when you get to F, where for some reason the 2011 law has been inserted.
Do we know when this was first noticed, this mistake? Or do you
Well, I
expect
think-
someone to pick it up at the time and perhaps pointed it out?
I don't think anyone did pick it. I mean, I think it was when I was instructed for the appeal and I was preparing the appeal and seeking to work out why the Court of Appeal hadn't dealt with what seemed to be our main point. And the reason for that seemed to be they'd been proceeding on a premise as to the legislation they were dealing with. But it's curious, and I'm afraid I haven't done this detective work to go back and try and see what may have happened.
Yes, right.
Because the Grand Court got it right.
Yes.
Indeed, drew a lot of attention to the difference between
Yes.
the two acts.
I mean, it's very odd because, as I say, E is correct. E is from the 2007 law, and one knows there were minor drafting changes made to E in the 2011 law, and E is definitely from the 2007 law. So I can't quite offer an explanation for why F all of a sudden reverts to the 2011 law. But obviously there are critical differences because the 2011 law introduced specifically reference to the share premium account. Now,
Yes, but is it... It also deleted some references elsewhere, didn't it, to the share premium account? I think it rephrased section 34, didn't it?
yes.
Anyway, we've got...
Yes, I think that my learned junior suggests that change was made to section 37.5e, where there was a deletion of the reference to the share premium account in the 2011 law.
Right.
So there was that change. Now, the other error we suggest one sees in paragraph 35. And this really actually combines the two errors. I mean, in the second sentence, you'll see there's a reference made to F, and the wrong version of the company's law is picked up there because the judge relies specifically on the fact that refers to funding the redemption out of the share premium account. But in the prior sentence, there's another point which is made, which is, in our submission, seeking wrongly to treat E and F as somehow operating independently and separate of each other in relation to the nominal amount and the premium. Now, in our submission, that's not right and doesn't reflect the fact that those conditions were cumulative in nature, and one can't somehow have E operating to the premium to allow a valid payment of premium in circumstances where F isn't satisfied in order to permit a valid payment of the nominal amount. And there's no recognition in our submission in the Court of Appeal's judgment anywhere that those two conditions both have to be satisfied, and one can't treat them as operating in effect in isolation and as treating the premium as completely divorced from the nominal amount.
So they thought that there wasn't a problem in this respect because they thought that you could satisfy both the nominal amount and the share premium out of the premium account because they misread the...
Exactly. And that's really the reason why it's an unfortunate error, because one can see that it's distracted them from our argument and the critical force of the argument, which depends on 37.3f. And one suggests if they'd been focusing on the correct language, they would have approached it in a rather different way. Now, although the respondent doesn't make this point expressly in its written case, there is some suggestion in parts of its argument that it intends to advance the argument that the conditions in E and F aren't cumulative, that they don't both have to be satisfied, and that somehow you can apply the one separately to the premium and the other to the nominal amount. Now, in our submission, that is wrong. We've dealt with the point in our written case at paragraph 72 through 78. Really, beginning at paragraph 73. The first point we would make is that the process of redemption of a share applies to the share as a whole. It results in a single liability to pay the redemption price. And if you look at the articles of this fund, common to many funds, the mechanics are that the shares are redeemed at the prevailing net asset value on the relevant redemption day, and there's a single liability to pay the redemption proceeds, and that simply consists of the number of shares being redeemed multiplied by the NAV, less any applicable redemption fee. Your Lordships can see...
But part of that value is attributable to the nominal value of the shares, and part is attributable to the premium. There is that distinction.
Well, there is. As a matter of arithmetic, if you like, that part of the redemption price, which is in excess of the nominal amount, is by process of deduction the premium. And that's simply a matter of maths. I mean, you take the redemption price, you deduct the nominal amount, what you're left with is by definition, the premium. But our point is, if you look at the mechanics of this generally under the company's law and under the articles, there's a single liability on the company to pay the redemption price.
I mean, can it be put slightly differently? I mean, the one thing that you need in order to talk about repaying the premium is a redemption of the share in respect of its nominal value. So even if you view them as separate, you can't have the premium being redeemed in the air.
No, you can't. No, exactly. Otherwise, a premium on what? Otherwise, one asks. I mean,
Yes, I mean, you have to read E and F together.
Yes.
F does not include the premium as such, but unless you can achieve F, you don't get into E. That essentially is the point.
That's exactly right. And that is for that reason we say it was slightly odd that the order of them was reversed, because actually the original logic made more sense, that you have to satisfy F, and then if you satisfy F, you then move to E and see if you can satisfy that. But just to make good the point on the articles, and just to show your Lordships that, it's in the record behind divider 22. Page 314, Article 68. And your Lordships will see, in a way that's very common.
Sorry, where was this?
Article 68, page 314.
314, thank you. Yes.
It's a very common mechanic for mutual funds, and the redemption price which is due is simply the net asset value which is prevailing on the relevant redemption day, effectively multiplied by the number of shares being redeemed. And then there is an ability in Article 70 to deduct a redemption fee. But then under Article 70, it's those redemption proceeds which then fall to be paid to the creditor. So redemption of a share is a process that takes place in relation to a share generally. It's not something that takes place separately in relation to the nominal amount and the premium. It results in a single liability to pay a single sum. There's no division of the nominal amount and the premium. We also say any argument that they apply, these conditions somehow apply separately, makes no sense as a matter of policy or indeed of practicality. It's very difficult, we suggest, to see that the legislature could have intended a situation to arise where a redemption payment could validly be paid as to premium, but not as to nominal amount. I mean, one asks oneself, well, what conceivable reason could there be for seeking to engineer that sort of situation?
It wouldn't really be a redemption, would it?
It wouldn't.
You wouldn't have achieved the whole thing.
It wouldn't, and
Well,
one asks
we've probably
oneself,
got that.
Well, that's why I mentioned at the outset 32.2f, the purpose is providing for the premium payable on redemption.
yes,
If there isn't a redemption,
no premium.
so, and you say, therefore, you meet F before you get to E
Yeah.
in 37.
Exactly. And in that way, in our submission, that's a helpful way of looking at it. And in some ways, you simply go back to asking yourself, well, what does premium mean?
Your paragraph 73 is very clear in your case.
So, well, those are basically our submissions on section 37, and ultimately we rely on section 37(3)(f), and we simply say that wasn't satisfied here, certainly as to the nominal amount. And the only way it could have been satisfied is through 37(5), but the company wasn't solvent. Now, I've already touched on this point, but just to make sure I've dealt with it, because the Court of Appeal relied on it. Section 34(2)(f), which is the provision we've already looked at,
Yes.
allowing the company to use the share premium account to provide for the premium. The way in which the Court of Appeal seemed to approach 34(2)(f) was to say, well, this allows for a freestanding gateway to pay the premium without satisfying any solvency test, and in effect irrespective of whether or not it was permissible to pay the nominal amount. Now, in our submission, one simply can't get that out of 34(2)(f). It's providing for the premium. The premium only becomes due if one has in fact validly redeemed as to the nominal amount. But in any case, as you can see in our submission from the preceding legislation, all 34(2)(f) was doing was effectively the other side of the coin to 37(3)(e), and was making clear that it is a permitted use of the share premium account to provide for premium due, but the conditions as to making of the redemption payment, and which have to be satisfied in order for the redemption to take place, are those set out in section 37. And it's not in our submission possible to read 34(2)(f) as somehow providing for some freestanding gateway for the payment of the premium. One is driven back always to section 37(3), which is the relevant provision which sets out the conditions which need to be satisfied in order for the redemption payments to be valid. Now, so far as the respondent is concerned, as we understand its written case, its argument very much focuses on 37(3)(e). I think what is said is that if you look at 37(3)(e), there's three alternative sources from which the premium can be paid, namely profits, the share premium account, or in the manner specified in subsection 5. And it's then said that the solvency test in section 37(6) only applies in relation to the last of these. Now, our short point on that is that misses the point and misses our case. I mean, our case is not a case based on 37(3)(e), it's a case based on 37(3)(f). And it's not a necessary part of our case to say that the condition in section 37(3)(e) was not satisfied in the present case. And we certainly don't say the share premium account cannot be used to fund the premium due on the redemption. But all of everything in 37.3e takes as its premise that 37.3f has been satisfied. And we say 37.3f clearly has not been satisfied in the present case. And if the solvency test in 37.6a was not met, then there was no permissible source from which the redemption payments, certainly as to nominal amount, could be funded. And one doesn't even get, therefore, to the stage of looking at the premium. So, my lords, really that's all we have to say on the construction point, which we do submit on analysis is a relatively straightforward point, looking at 37.3f and the available sources in the present case. Now, the next question, assuming I'm right about that, is the question of insolvency, which is, was 37.6a satisfied or not in the present case?
Just before you go there, do you derive anything from subsection 5E? If the capital payment is greater than the nominal amount of the shares redeemed or purchased or cancelled, the amount of any capital redemption reserve, share premium account, or fully paid up capital of the company may be reduced.
Yes.
Accordingly. Do you drive anything?
Well, I mean, to this extent, that's helpful for my case because that envisages using a payment under 37.5, which has the effect of reducing the share premium account. But obviously, all of that is subject to 37.6a. So, I mean, although I don't think I need to go this far, but that strongly suggests that if you're using a payment from 37.5 to reduce your share premium account, you would have to satisfy the solvency test in 37.6a. Because what 37.5e has in mind is you make the payment from the general assets, and the payment you make is in excess of the nominal amount of the shares. Therefore, you can use that excess to reduce your share premium account.
Doesn't that throw light on the interrelationship of 37.3e and f as well? Does it not suggest that you don't have to, insofar as the premium is concerned, you can simply satisfy that out of the share premium account, even though that would really result in a reduction in capital? In other words, you don't have to find equivalent profits which you put into the equation and possibly put into some capital redemption reserve.
Yes.
All you have to cover is the actual nominal value out of the profits. The premium you can take out of the premium share premium account, effectively reducing capital.
Yes, no, I see that.
So,
But,
yeah.
I mean, I suppose...
It throws light on the sense in which E and F are cumulative. It may not be quite cumulative in the sense that your case puts it, it seems to me.
Yes. Well, I mean, certainly what one doesn't get from 37.5e, I mean, is any suggestion that that means you can make a redemption payment as to nominal amount in circumstances where
you haven't got the money, where you're insolvent.
Where you're not solvent.
No.
I mean, what 37.5e seems to suggest is that you can make a payment out of your general assets to redeem shares at a premium. Once you do that, the amount in excess of the nominal amount can be used to reduce the share premium account. But of course,
Still subject to the solvency.
Exactly, but any payment under 37.5 has to be subject to 37.6a.
No, so there's a general solvency requirement which would apply. Yeah.
And subject to solvency, there's a very liberal ability to use the share premium.
Absolutely, and that's Section 34 says you can return all your capital return all your share premium account to members if you're solvent.
Yeah.
But all of this turns on solvency, and that is really the underlying policy in our submission, which is the foundation of this legislation.
On cash flow solvency, it may be agreed, but insofar as you're looking at the total sums required to satisfy all redeeming shareholders, those total sums include the premiums. But if it's right that you don't have to cover the premiums because you can just write them off against the share premium account by way of reduction of capital, does that mean that the solvency test is easier to satisfy and that you may have been looking at it in a way which is incorrect?
No, it doesn't, because the way this works in our submission is that the redemption itself is not impugned. So the process by which the shareholder converts from the status of shareholder to become a creditor is not impugned under legislation. That's not how it works. What the legislation does is it attacks the payment made to the former shareholder. That's how 37(6)A works. So they're still a creditor. The company still owes them the debt in respect to the redemption proceeds. Simply, they're not entitled to hold on to the monies they received in discharge of that debt. And they have to return it, and then they will prove as a creditor in the statutory scheme alongside other redemption creditors. So it's still a debt in our submission one takes into account. Now, perhaps we need to have 37(6)A in front of us, given it's the key provision for these purposes. It's divider 4, page 568. And one sees really the critical words in the penultimate and final line. The company must be able to pay its debts as they fall due in the ordinary course of business. Now, the respondent basically argues that the words ordinary course of business qualify the type of debts which are to be taken into account for these purposes. They say redemption proceeds are not debts owed in the ordinary course of business, and that if you ignore those liabilities, there's no evidence that DD Growth was unable to pay its other debts. Now, that was an argument which was rejected by the Grand Court, rightly in our submission, but which the respondent seeks to revive on this appeal.
The basic rejection was on the grounds that a feeder company has no business except issuing or taking investments in the form of redeemable shares.
I mean, the Chief Justice, quite understandably in our submission, thought that the ordinary course of business of a Cayman open-ended mutual fund included accepting subscriptions and making redemptions. And
that's all it does, apart from pay the stationery and the clerk.
Well, I suppose it deals with the other side of the business as well.
Put some investments into a master fund in this case, and in the case of other funds...
But it just automatically feeds it into the prescribed master funds, doesn't it?
Yes.
There's not much investment judgment going on, except the initial one, that those are the funds to be, which represent the real asset.
Exactly, and even if you didn't have a master feeder structure, I mean, normally it would just be handed over to an investment manager and he'll be told to get on with it. And
when you invest, you presumably know where the master fund is, what the master fund is.
Yes, there's an offering memorandum, details of that. Yeah, so one knows what one's getting into, at least in broad
The investment
terms.
manager would be an agent of the feeder fund,
Yes.
whereas the master fund is not.
That's right, yes.
Right.
So we have three reasons why we say the respondent's argument on this point is wrong. The first is a reason based on the language of section 37(6)A itself. And we say, simply as a matter of language, the words in the ordinary course of business qualify the immediately preceding phrase as they fall due, and don't qualify the type of debt which is to be taken into account. And rather, how this works is that all types of debt are to be taken into account, but that in assessing solvency, you consider not only the company's present ability to meet its debts which are presently due, but also its ability to meet debts which fall due in the future in the ordinary course of business. So if you like, it's a temporal qualification rather than the qualification that goes to the nature or the substance of the debt itself. And indeed, if the draftsman had been seeking to exclude particular categories of debt, this would have been an inapt type of language to have used. I mean, he should have used something like, should be able to pay its debts incurred in the ordinary course of business as they fall due. I mean, that would be the formulation on the respondent's case, but he hasn't done that. And in our submission, the words "in the ordinary course of business" are temporal. They qualify and provide an explanation of the assessment process of looking at the company's ability to meet debts which will fall due in the future. Now, we've explained in our written case why it's likely the draftsman wanted to make that clear, because there has historically been some controversy in the Cayman Islands in relation to the test for solvency for winding up, as to whether you take future and contingent liabilities into account. And that was a point of some controversy. It's now less of a point of controversy because of a decision in Weavering. But prior to that, there were divergent views on whether future and contingent debts are taken into account for the purposes of solvency for winding up in Section 95C. Now, against that context, one can see why the draftsman, when it came to 37(6)A, would want to make it quite clear that for these purposes you do take future and contingent debts into account as part of the cash flow solvency test. So it's not in our submission, it's unsurprising that that language was included. Now, just looking at 37(6)A, as I was submitting a moment ago, that there's no doubt that unpaid redemption proceeds are a debt of the company. If a shareholder has been redeemed, he ceases to be a shareholder and he becomes a creditor of the company for the redemption proceeds, and those are a debt owed by the company to the shareholder. Now,
can I just intervene?
Yes.
Track back slightly.
Yes.
I quite understand your submission that 6A is only rendering unlawful a payment in connection with redemption.
Yes.
But 3F, how do you address 3F, which says shares may only be redeemed routes, and if one of the routes is the manner provided for in subsection 5, and you can't do it in the manner provided for because 6A makes it clear that there's a solvency test,
Yes.
why is the redemption possible and therefore lawful at all?
Well,
I accept that it seems to be common ground,
Yes.
but it is. But I've had a problem about this from the start of reading into this case and would like your assistance.
yes, I mean, that's obviously something that's occurred to us as well. I mean, it seems to us the answer is this. I mean, Section 37(3) sets out a number of conditions, if you like, which have to be satisfied. But Section 37(3) itself doesn't tell you what the consequence is if those conditions aren't met. Now, the common
law does then, doesn't it?
Well,
because you're not within a statutory gateway out of the common law prohibition.
Yes, but the common law rule attacks the distribution and the payment. And I can go back and show you how it's formulated in progress property. But the common law rule in our submission wouldn't say that the redemption is necessarily invalid in the sense of the conversion of the investor from the status of shareholder to creditor. What it does say is invalid is any distribution made to that former shareholder. And that's certainly the way it's put in our submission accurately by Lord Walker in Progress Property at paragraph 15. And one sees essentially the same approach in section 37(6)A.
Well, when you talk of something being done out of the profits of the company or out of the proceeds of a fresh issue of shares, you must be talking about payment.
Yes.
You can't be talking about the transaction which gives rise to the obligation to make the payment, because the obligation exists regardless of where it's coming from. This is only dealing with where you're going to get the money.
Yes. I respectfully agree, yes.
Well, doesn't that, though, throw doubt on what I thought was your proposition, that the redemption is separate from the payment and that the present shareholders must be regarded as having successfully redeemed, and all that remains outstanding is payment. But if F is a condition linking the validity of redemption to actual available profits or available capital, then that analysis is more difficult, isn't it?
Well, I mean, I thought my Lord's point was directed at the payment rather than the redemption, and that's certainly our submission. That
yes, but I mean, I thought it was also addressing F in section 37(3)(f). Which
yes, but I think the point is what 37(3)(f) is really directed at is the payment. It uses the language may be redeemed. But then, as my Lord Sumption observed, it's then when it talks about, goes on to describe further in that section, it talks about redeemed out of the profits or out of the proceeds or in the manner provided for is subsection 5. So it's clearly focused on.
We're talking about the payment pursuant to the redemption.
Yes.
Otherwise, a redemption, if you redeemed, you wouldn't even be a creditor.
Exactly.
In an insolvency.
Exactly. And it's the other point on this is, of course, it's perfectly possible under this regime, in the present case, for someone to be redeemed on day one, but the payment not to fall due until perhaps a month later. I think your Lordship's accepted in the Pearson against Primeo case. That is a possibility. So, I mean, it's conceivable to think of a situation where the shareholder might be redeemed at day one, but then it's not entirely clear at that point where the payment's going to be funded from. Perhaps in the meantime, further investors subscribe, perhaps a loan's made available or whatever. I mean, there may be that time gap, which I would suggest would tend to illustrate that although at first blush one can read F as focusing on the process of conversion from shareholder to creditor, it's really directed at the payment.
that does require a bit of revision, doesn't it, of the earlier analysis which you advanced in broad terms as being that Section 34, for example, is just introductory, explaining ways in which the share premium account may be applied. Section 37 is the conditions of redemption, but it's not, you're now saying. You're saying that it's part conditions of redemption, part conditions of payment.
Well, in our submission, it depends, actually, which condition you're looking at, but certainly E and F are focused on the payment. Now, I quite accept that, for example, A...
I mean, perhaps the trouble is, I think we noticed this in Pearson and Primeo, is that it's only recently in these schemes that one comes across a separation between the redemption and the payment. The idea of delaying payment, normally you get cash against goods. So
Exactly.
But I mean, the delay is almost invariably, in fact, probably absolutely invariably the case with an open-ended investment company, is because you can't actually manage it otherwise. You have to have an application for redemption before the NAV per share is identified, and then subsequently a payment.
And try to raise the liquidity in the meantime.
Exactly.
well, you might be able to structure it so that you
Borrow, I suppose.
borrowed or sold sufficient assets before the actual redemption date, before the 1st of December.
Yes.
How much notice in advance do you have to give? You have to give a month. Probably.
It's usually within the month preceding the fixing of the NAV.
Anyway, we've got your...
So, I mean, the point is on that, certainly E and F are focused on the payment, and if one asks oneself what the consequences are of not meeting and satisfying the conditions, both under the common law rule and under the 36...
Let us pick up.
Yes.
E is in different terms, because there it specifically talks about you're providing for it in advance of the before, at the time, the shares are redeemed or purchased. So you're making a provision.
Well, it is, but it doesn't. I mean, it does talk in the opening line about the premium payable on redemption. So, I mean, that...
Well, yes, it's saying at the time of redemption,
Yes.
you must provide for the premium to be payable. So
Yes.
visiting that there may be a gap in time.
But I mean, but if one's asking oneself, well, what is it that the condition in E is biting on? I mean, it's really, in our submission, biting on the validity of the payment of the premium. And it's saying, we would suggest in substance, that in order to pay the premium, you have to provide for it out of profits or the share premium account. You have to make that provision, or have been in a position to make that provision before at the time the shares are redeemed. But that's our position, and as I say, I mean, our case, I mean, we don't put it at common law, we put it on the basis of 37(6)(e). The outcome would be the same in our submission, because in both cases the relevant rule renders the payment or the distribution unlawful.
So I wonder whether we shall have just a 5-minute break, since we sat a little early. How are you doing in your submissions?
I'm doing quite well, actually. So.
I got the impression that you were. How long are you going to take on the remedies side?
Restitution is going to take a bit of time.
Yes.
I'll certainly...
We might just consider briefly whether it's sensible to move straight on to that, or whether it's sensible to hear Mr. Chivers on this.
Yes, well, I mean, very much in your lordship's hands on that. Yeah.
Well, we'll rise.
Thank you.
Subject to anything either of you wants to say, I think it's quite likely we would want to proceed to hear Mr. Chivers on the present point, and then revert to you for you to open the remedies and deal with it as a separate matter, although...
Yes, absolutely, my lord. I will finish, therefore, the insolvency point, which I was on just before the break. We were looking at 37(6)(a), and in our submission, there's no doubt that unpaid redemption proceeds are a debt.
Yes.
Under the terms of the articles, the relevant shares were redeemed on the relevant redemption day.
Right.
And if your lordships go to the articles, divider 22 of the record, page 314.
Yeah. Yes.
Article 66, a member may request redemption of all or any number of his ordinary shares on each redemption day. And then 68, which we looked at previously, the shares are redeemed at the NAV on the redemption day. And then, perhaps most clearly, if one then goes to 90, page 317, one sees it's at that point, i.e. on the redemption day, that the former shareholder ceases to be a shareholder, ceases to be entitled to any rights in respect of his shares, and is liable to be removed from the register, and the share or shares are available for reissue. And that all happens on the redemption day. And obviously, to the extent the redemption proceeds haven't been paid, he will be a creditor of the company for that.
Is there a provision dealing with the date of payment?
Not really. I mean, it's paragraph 7, Article 74. Deals
in such
with
period as the directors
Yes.
shall determine. So, I mean, they could, for example, determine that payments shall be made within 3 weeks of the redemption date.
Yes. And we will, my learned junior will check whether there's any more information on that in the offering memorandum. It's sometimes...
the offering memorandum, certainly in Pearson Primaire,
Yes.
did contain something about it. Said usually within 21 days or whatever.
It did, exactly. We'll just have a look and see if there's anything on that. But that's certainly it so far as the articles are concerned. Now, the scheme of the articles in this respect is essentially no different from those which your lordships previously considered both in strategic turnaround and in the Pearson against Primeo cases, and they work basically in the same way, in a way which is familiar. It provides that the redemption day is effectively the point at which the investor ceases to be the shareholder and becomes a creditor. Yes, perhaps I'm grateful to my learned junior. If your lordships go to divider 23 of the record, page 386. It's right at the bottom of page 386. Payment of the redemption proceeds together with any unused equalisation credit paid in respect to the redeemed shares.
So 306.
386.
386, sorry.
Yeah, so within as soon as possible, within 14 business days in any event.
Yes.
What is this document?
This is the offering memorandum. So this is the document basically issued to prospective investors in the fund and the basis on which they make their investments. Now, as I say, I mean, essentially this works in no different way to the articles which your lordships considered in strategic turnaround and Primeo. It's basically the same structure. Now, it's true that in a liquidation, as a matter of priority, debts owed in respect of redemption proceeds are subordinated to debts owed to non-shareholder creditors. Your lordships found that in Primeo against Pearson, but they nevertheless remain debts of the company. Your lordships held in our submission entirely correctly that unpaid redemption proceeds are a provable debt. Paragraph 22 of Pearson against Primeo.
It's a matter of submission, whether it's correct.
Yes. Well, I mean, it's certainly, if one looks, the definition of debt within the Act, as you may recall, I mean, plainly in our submission encompasses payments due to a former shareholder, even though as a matter of right of payment, under section 49G, they're subordinated to debts owed to non-shareholder creditors. So that's our first reason. Section 37(6)(a) is concerned with debts generally. Ordinary course of business isn't a gloss on the type of debt, and that the redemption proceeds in the present day case are plainly debts, unquote. Now, the second reason is, even if we're wrong about that, and the language ordinary course of business qualifies the type of debt to be taken into account for the purposes of the solvency analysis, then redemption debts are debts incurred in the ordinary course of business of this company. Now, we've already touched on this point, but in the case of an open-ended mutual investment fund, such as DD Growth, its whole business revolves around accepting and redeeming investments from investors. And a debt incurred in respect of redemption proceeds would be a debt incurred in the ordinary course of its business. And indeed, at the risk of making a slightly glib point, I mean, if the draftsman had intended to exclude redemption debts from the solvency analysis, then there would have been much more obvious ways of doing that than using the ordinary course of business formulation. If you think of the draftsman sitting in the Cayman Islands, surrounded by open-ended mutual funds, redeeming thousands of investments a day, I mean, if he'd wanted to exclude redemption debts from the solvency test, I mean, he would hardly have used the language ordinary course of business. There would be much more obvious and apt ways of dealing with that. Now, it's clearly the view of the Cayman courts themselves that redemption debts are debts incurred in the ordinary course of business of companies such as DD Growth. One sees that from the Chief Justice in the present case, behind divider 4, page 69. It's paragraph 130 on page 69. he said no authority should be needed to establish that redemptions of shareholders form part of the ordinary course of business of a Cayman Islands hedge fund, but authority to that effect can be found in JP Morgan against Macro Fund. We have that authority. It's behind divider 13 of authorities bundle 1. And this is another decision of the Grand Court, this time Mr. Justice Henderson. This was a case where a moravian injunction had been sought against a fund in order to prevent it from making redemption payments to investors. And that was rejected because the court considered that the making of redemption payments was in the ordinary course of business of the fund and therefore couldn't be said itself to amount to evidence of a risk of dissipation of assets. And the relevant parts of the judgment are really paragraph 10 on page 623. The judge applies his mind to the test, whether a dissipation of assets must be intended or not. The authorities are in general agreement that transactions in the usual and ordinary course of the response business do not amount to dissipation at all. Something more is needed. So he's identified the test, and then paragraph 15 over the page, he answers the question. It is in the usual and ordinary course of the business of each of the two macro funds to redeem a member's investment upon request. It is true that the investor is not a creditor but a shareholder in the company. I do not think this distinction in the particular case of a mutual fund like these makes a difference. From the moment of the inception of a mutual fund, it is expected that it will, in the usual and ordinary course of its business, issue shares in exchange for investments and redeem those shares. The shares are its stock in trade. It should not be prevented by a moravian injunction from responding to routine requests for redemption. So a different context, but applying broadly the same test and reflecting what in our submission is the reality, that redemption debts are in the ordinary course of business of a Cayman mutual fund. Now, there's 2 points I just wanted to deal with which RMF, the respondent, makes in its written case at paragraph 60 through to 62. Which is page 524. Now, the first point, which is really made at paragraph 60 to 61, is, I think, said to be a practical point. And it's said that it would be odd if a company faced with a redemption request, which it only had funds to pay 90% of, could not pay that 90% at least. I mean, that is said as an oddity. If that was now, 2 points in response to that. The first is that a company or a fund is very unlikely in practice to want to pay only part of outstanding redemption proceeds.
Oh, I thought that's what's happened, yeah.
Well, exactly, but the problem with doing that, of course, is you're then at risk of having a winding up petition presented by the investor for the unpaid part of it. So a company is unlikely to be willing or wishing in our submission to take that route. And the second point is that, in fact, the answer to this sort of situation is that in practice, where a fund is faced with liquidity issues, which mean it temporarily cannot meet outstanding redemption requests, it will invariably have power under the articles to suspend the redemptions and or the payment of redemption proceeds. So it has a mechanic whereby if it knows it's not going to be able to make the payment, it will simply put the shutter down, either temporarily or permanently, give itself a breathing space until it is in a position to do that. And one sees that power in the articles in the present case, in Articles 53 and 54, which are back in the record again, behind divider 22. So Article 53, on page 311, there's a general power to suspend the calculation of the NAV. And then that links into Article 54 over the page. Which basically provides for the power to suspend redemptions. So by suspending determination of the NAV, you suspend the liability to have to redeem. And then separately, and in addition, there's also a power under Article 89 to delay making redemption payments. It's page 317. But what it basically provides is that if the company faces difficulty in raising liquidity because of difficulties in the realisation of an asset, it can suspend payment of the proceeds or that relevant part of the proceeds. So there's general powers both to suspend redemption and to suspend the making of redemption payments. No. So in our submission, the situation posited by the respondents is very unlikely to arise because no company is going to want to pay part of the redemption proceeds. It would be at risk then of having a winding up petition presented. The more obvious course would either be to suspend the NAV or to suspend payment of the proceeds.
Yes.
Now, the second point, which I think is mainly made in paragraph 62, is I think to say that redemption debt should not be taken into account for the purposes of the solvency test in section 37.6 because the redeeming shareholder is not someone who has granted credit to the company on the basis of its share capital. Now, we simply disagree with that point. It seems to us a shareholder, once he's been redeemed but remains unpaid, is someone who has granted credit to the company. And the credit which he has advanced is the unpaid redemption proceeds. I mean, it's true he hasn't handed over cash to the company, but he has advanced credit to the company. One doesn't need to hand over cash in order to become a creditor. And an unpaid redemption, an unpaid redeemed shareholder is as much a creditor as anyone else is who's owed a liability by the company. And that, I respectfully suggest, is the way in which your lordship saw it in the Promeo case, which is behind Divider 20, paragraph 13. Page 806 of the First Authorities Manual. And your lordships were dealing here with the nature of redemption, and it's obviously concluded that payment is not an inherent element of redemption or repurchase. But your lordships go on to say, make the point in the final sentence of paragraph 13, that if the redemption proceeds aren't paid on the redemption date, then in effect there is a grant of credit by the redemption shareholder, by the redeemed shareholder, to the company. In our submission, that is right. I mean, he becomes a creditor on the redemption day. He's not paid. He has advanced credit to the company. And as a creditor,
you effectively agree to advance credit by entering into the transaction, buying the shares.
Exactly.
On the terms. Yeah.
Exactly. And the
You're just an involuntary creditor, like the Inland Revenue is from time to time.
Yes. Well, involuntary in the sense he didn't get his redemption proceeds when he would have liked them, yes.
He wasn't voluntarily advanced. No. It's just an involuntary credit. Somebody's not paid when he should be paid.
Exactly. But he's still a creditor. And the critical point is, as a creditor, he's someone who's equally entitled to the protection of the share premium account as any other creditor. I mean, why is it that the share premium account is for some reason not there to protect him when it is there to protect other creditors? So in our submission, that isn't a good reason for construing Section 37.6a in the way in which the respondent suggests. And ultimately, in our submission, one is just driven back to the ordinary meaning of the language here, which we suggest is not actually really particularly unclear or even ambiguous. Now, the final point...
It'll be all three, is this?
This is point 3, yes. So the final point is a factual point, which is that the unpaid debts of DD Growth in the present case, in any event, included liabilities other than redemption debts. Now, this was a fact which was not common ground before the Grand Court, and still is not common ground. Your Lordships will see, it's recorded in the Statement of Facts and Issues for this appeal at paragraph 11 as not being common ground. And likewise, if you go to the Statement of Agreed Facts, which are before the Grand Court, which are in Divider 21 of the record, it's page 269.
Sorry, could you give that page number again?
It's 269.
Thank you.
Now, just looking there, you'll see there's a table referring to the financial position of the company as at the 31st of December 2008. And under the liabilities heading, some items were agreed. So, for example, it was agreed there were redemption liabilities of just under 79 million. But there were other liabilities, as reported by the fund, in respect of accruals and certain fees, which were not agreed. And now, the Grand Court obviously didn't make any determination as to those other liabilities because it didn't need to, because it proceeded on the basis, well, the redemption debts fall to be taken into account for the solvency test, and it plainly was insolvent on that basis. But if your Lordship's against me on everything I've said so far on insolvency, and this case does turn on us having to demonstrate it was insolvent by reference to non-redemption liabilities, then that is something which would need to be remitted back to the Grand Court for it to decide on the evidence. I accept, obviously, your Lordships aren't in a position to decide that. There are references in the respondent's written case to there being no suggestion that there were no creditors of the company other than redeeming investors. For example, they say that at paragraph 82 that's wrong. There is a suggestion, more than a suggestion, it's just that was not either an agreed fact or something that resulted in the finding made by the Grand Court.
Which paragraph is paragraph 82, did you?
It's 82, I think, of the respondent's case.
I see, right. Okay, so you say that's wrong, right?
Yes, I mean, when it says there's no suggestion in the papers, I mean, just looking at the agreed statement of facts before the Grand Court.
Right.
And I should say, just by reference to that, the liabilities recorded there are those liabilities recorded by the administrator on the net asset value statement, which were produced by the company and used to do the redemptions and subscriptions. And subject to your Lordships, that just leaves me to deal with remedy.
Thank you very much indeed. Yes, is there anything you want to add, Mr. Alatar?
My Lord's name.
Yes, Mr. Chivers.
My Lords, rather like my learned friend, start with the history, and I hope you'll forgive me for going over ground my learned friend has gone over, but I'd like to place a slightly different gloss on it, so please do bear with me. The first thing, though, just by way of overview, is that although Cayman and English law had common roots in the field that we're looking at, the position in Cayman and England split. And one has to be very careful not to take notions of capital maintenance as regards share premium account from the English law as we have practiced it since 1981. Secondly, it's not been suggested by my learned friend that Cayman law has become more restrictive in the manner in which shares can be redeemed since the 1963 Act, or the 1948 English scheme, if you like. And indeed, it would be rather odd were that to be the case, given one can see the policy in Cayman has been to allow share premium account to be used in circumstances where it could not be used in England. Now, we would say this, that if Cayman was still operating under the 1963 Companies Law, 1948 English Companies model, these payments would have been lawful. So we're not relying upon any new extended permission to use share premium account that certainly has been created in Cayman. We say that on perfectly ordinary, conventional 1948 type grounds, we are within the scope of these payments. And that's subject to one thing, that it had not in England been determined prior to 1981 as to, as far as I'm aware, as to whether redemption and payment had to be simultaneous. Now, this panel has determined in Culross and Primio that in Cayman, redemption and payment do not have to be simultaneous. There can be a gap between them. They may be two separate processes. And so, of course, we have to look at Cayman law in the light of those decisions. In England, the position not having been determined prior to 1981, statute addressed the issue in 1981, and when the law changed in England so as to allow generally the redemption and purchase of shares, not simply redeemable preference shares, that was accompanied by a statutory provision that said that payment had to be on redemption. So a redeeming shareholder never became a creditor of the company in competition with other creditors, the share having been redeemed. And provision was made where the share ought to have been redeemed but hadn't been redeemed for that claim and how that claim would rank as against other creditors and as against other shareholders. But other than that, it was payment on redemption. So this jurisdiction...
Was that point touched on in the Primeo judgment? I mean, I remember it coming up, but I don't know. Is it mentioned in the judgments? The difference of the English position?
I can't recall offhand. No. I can't recall offhand. So if we start with the 1929 Act, as my learned friend did, at Bundle 1, the authorities, tab 7, I'd only point out a few things. The first thing, of course, is that under 46(1)(a), which provided that no shares shall be redeemed except out of profits of the company which would otherwise be available for dividend or out of the proceeds of a fresh issue, of course, share premium at that point was profit of the company available for dividend. And that's the Drown case, which my learned friend referred to. So right from the outset, the starting point was that preference shares could be redeemed out of share premium. There was no share premium account as such because there was no statutory obligation to create such an account. Share premium was simply profit of the company. The second thing to note is that Proviso C, which says where shares are redeemed otherwise than out of the proceeds of a fresh issue, there shall out of profits which would otherwise have been available for dividend be transferred to a reserve fund, capital redemption reserve, a sum equal to the amount applied in redeeming the shares. Now, we know that must mean the premium. The nominal amount, because only the nominal amount needs to go into the capital redemption reserve to maintain capital. And then the premium payable on redemption, dealt with at D, is very clearly separate from that. So the language used, the amount applied in redeeming the share, that's that which is necessary to pay back the nominal amount of the share. The premium is clearly a separate item. So the history of the section tells us something about the redemption of the share being the repayment of the nominal amount and the premium being anything above that. Now, rather curiously, this section didn't provide for what was to happen in respect of premium where shares were redeemed out of profits. You can see that condition D provided where shares are redeemed out of the proceeds of a fresh issue, the premium must have been provided for out of the profits before the shares are redeemed. That is a point, and we only need note it, was picked up in the commentary of Palmer's company law, and it's at Bundle 3, tab 62 at 1708, for your reference. I'm not going to take you to it, save to say that Palmer was not complimentary as to the drafting of this section.
Which page?
It's at 1708 of the bundles. Tab 62 is the 1708 is where the reference is to the preference shares, and there's an analysis there of section 46 of the Act. And one can just look halfway down. Section 46 is badly drafted. It was extremely difficult to understand. Where shares were redeemed out of profits, there appeared to be no provision that any premium had to be provided out of profits. So we need to be concerned with the detail of that because, of course, we're working on a rather more sophisticated version of redemption provisions. But it is just interesting to note that the distinction between premium and redemption, the amount needed to redeem, was already inherent in the scheme as early as 1929.
Is your submission that 46(1)(c) is only about the nominal amount?
Yes.
Supported by authority or invariable practice among company accountants?
No, supported by, well, this provision didn't last all that long, so I can't tell you what the invariable practice was between 1929.
I think you said one only ever put into the capital redemption reserve the nominal amount.
Exactly. I mean, I take it not from support, I take it from the language,
Okay.
which is that there's no sense in putting into the capital redemption reserve anything in excess of the nominal amount of the shares you're redeeming. The whole scheme of the thing is to preserve capital, not to increase capital. It would be odd if on a redemption of shares your capital base then increased.
Yes, in an era when premium was regarded as profits,
Exactly.
not capital.
Yes.
Exactly. So that does take us to the 1948 Act, or one can look at it in the 1963 Companies Law in Cayman.
The Palmer makes clear that the 1947 Act was introduced before the 48 Act.
That's right.
These consequential amendments,
That's
necessary amendments, including the reference to the nominal amount.
That's right. So it was picked up in 47, and then in the consolidation in 1948, it appears as we now see it. But that period, certainly between 29 and 47, the provision was as you've seen it there. Now, in 1948, but I'd rather take this from the Cayman statute because we are dealing with the history of the position in Cayman. I think there's going to be any difference, but it's at tab 1, the authorities bundle, page 547. Now, of course, two things happened here. Firstly, Cayman law, I should say introduced, I'm told that there was a company's law of 1960 in Cayman. Cayman, prior to that, was part of Jamaica and had Jamaican law, which I think was based on the older English Companies Acts at that point, and I think Jamaica went to the 1948 Act a little later. But we can pick it up certainly from the 1963 Act. I don't believe it's any different from the provisions of the 1960 Act, which again were 1948 based. Mm-hmm. So this is now the introduction of the requirement for a share premium account in Cayman. Section 32, we've seen how that works. The premium has to be transferred to the share premium account. And then the provisions of this law relating to the reduction of the share capital of a company shall, except as provided in this section, apply as if the share premium account were paid up share capital of the company. Now, that's where we get the idea of quasi-capital from, the as if. And subparagraph 2 is the exception, and that includes, and we see, therefore, that this is always included. Ever since share premium account was a statutory requirement, it included a proviso that it could be used in providing for the premium payable on redemption of any redeemable preference shares of any debenture of the company. So such premium, if it's to be used in providing for share premium, if it's used in providing for premium payable on redemption of preference shares or debentures, is not treated as if it were capital. It's carved out.
Sorry, what we're looking at for that proposition?
We're looking at section 32(1) and 2 together. In other words, subject to the exceptions,
Yes, I see.
it's treated as if it were share capital.
Yes, except as provided. I see.
Well, subsection 2 isn't saying it's not capital, it's simply saying this is a situation, these are the circumstances in which capital can be, from that source, can be used to make payments out.
It's essentially saying that the share premium account can be reduced by that amount without
Reduction of capital.
reduction of capital, without treating it.
The two subsections relate to each other or cross-relate to each other. Yeah.
That's right. That's right.
Without being contrary to the rule against reduction of capital.
Well, of course, the common law rule doesn't apply to the share premium account.
No.
Common law rule only applies to the nominal amount. It's only the statutory rule, the requirement to put it into a share premium account, subject to these provisions, that stops share premium being profit. It's not subject to the Trevor and Whitworth common law rules on maintenance of capital at all. So, On the face of Section 32(2), a company can, without restriction, reduce its share premium account for the purpose of making those provisions. We then go to Section 34, and you'll see that we're still in the 1948 mould. This is the power to issue redeemable preference shares and preference shares only. And then the provisos. A, they shan't be redeemed except as profits, otherwise available for dividend. Proceeds of a fresh issue, not unless they're fully paid. And then C, the premium, if any, payable on redemption, provided for. Now, when the company redeems the share, there are, or may be, two processes in play. The first is that there's a reduction of capital by the nominal amount of the share. That has to be paid out of profits and a capital redemption reserve created, or it comes from new shares, which is new capital. So capital is maintained. And then there is, or there may be, payable to the shareholder in excess of the nominal value, a premium. That payment doesn't amount to a reduction of capital. No capital redemption reserve and no replacement capital is required. But the scheme of the Act does require that the payment shall not amount to a return of capital. When I say capital there, I mean capital properly so called. Trevor and Whitworth type capital, because it must be provided for out of profits or share premium account. So for this purpose, as we've seen from Section 34, Section 32, for this purpose, share premium account is not capital. So capital maintenance is maintained, save that for this purpose, share premium account isn't capital and doesn't have to be maintained. That's how the Act works. Now, if one were to start with the presumption that share premium was capital in the Trevor and Whitworth sense, that might be a surprising result. But the 1963 Act and the 1948 Act started from the proposition that share premium was profit. It was putting a restriction on share premium. And the requirement for the creation of the share premium account came into existence always subject to this particular gateway to use share premium for paying the premium on the redemption of preference shares. There was never a point at which share premium was prohibited from that use. So prior to 1948, it was lawful to use share premium to pay the nominal amount of shares redeemed because it was profit, as well as the premium. The restriction in 1948 was that share premium could no longer be used to pay the nominal amount, but it remained lawful to use the share premium to pay the premium on the redemption of shares. And that didn't represent a relaxation of the law, it represented a continuation of the law. So both before and after 1948 in England and after 1963 in Cayman, the position was, as it had always been, you could use share premium in respect of payment of premium on the redemption of shares or debentures. It might just be worth considering, of course, that not only can you pay the premium on redemption of a share, but on a debenture as well. It's interesting that a debenture is included in one of the uses, paying the premium on debentures. Now, looking at it from redeemable equity shares, of course, they're very different from debentures. But redeemable preference shares, certainly in the common commercial of preference shares, redeemable preference share and a debenture are very similar instruments. They're of a significant nominal sum and tend to attract a small premium reflecting the coupon that they carry. And that premium may vary depending on interest rates and the coupon and so forth. But they're very similar forms of capital raising for a company. You can raise loan capital by a debenture or preference share capital. The only difference realistically is one's above the line and one's below the line. But redeemable preference shares are essentially treated as debt for many accounting purposes. They're accounted for in the same way as a debenture. And the point of interest, I suppose, is when one thinks about redeeming the preference share, the person who has subscribed a £1 preference share on which they're going to get a coupon of 4%, 6%, whatever that may be, the redemption of that involves the repayment of the capital that was advanced on it, just as it with a debenture, a £1 debenture, carrying a coupon of 3, 4, 5%. You redeem that debenture by repaying the money, the nominal amount of that debenture. That's what the redemption involves. And a fully paid share actually does represent a liability of the company in any event. It's a below-the-line liability, or in old money, on the right-hand side of the balance sheet. But it's nonetheless a liability. It's a liability to the shareholder. It's a liability that generally is only repaid in a winding up. But if the terms of the redemption of that share require it to be repaid before winding up, then it's a liability that is due before the winding up. But the nominal amount paid up on that share in the balance sheet is a liability of the company. And the redemption of the share involves the elimination of that liability. Once the nominal amount is eliminated, that share no longer exists. And so references in the statute to the redemption of a share refer to the elimination of the nominal liability. I say we saw it from the 1929 Act, Section 46, and that same line runs throughout. The payment in excess, the payment in excess of the nominal amount isn't part of the redemption, because once you've got down to zero, you've eliminated the share. Any payment in excess of the nominal amount is referred to as the premium. Now, as I say, in relation to redeemable preference shares, when this jurisdiction was first created, it was relatively straightforward because these were shares commercially advanced at a particular nominal sum, and that nominal sum was repaid. Of course, now in Cayman, we're in a very different world where the nominal amount is very small and the premium represents a significant sum. But to the extent that it was lawful under the 1948 Act and under the 63 Act in Cayman for a company to use share premium to provide for the payment of a premium on the redemption of preference shares, that payment was expressly permitted because the Act provided that share premium wasn't quasi-capital when used for that purpose. And my learned friend took you to Professor Gower's report at tab 64. Of course, he didn't show you the most interesting part of that report for the purpose of this case, and I'll do that now. This was in the context of a consultation document, 1980, on the purchase by a company of its own shares. And Professor Gower, in his capacity as research advisor on company law to the Department of Trade, was looking firstly at the present legal position, 1748, and my learned friend took you to paragraph 3, and that's certainly the paragraph I was going to take you to. But over the page on 1749, he showed you that the premium on redemption, you can pick it up at the top of the page, must be provided for out of profits or out of the share premium account. Moreover, if redeemed out of profits, an amount equivalent to the nominal amount of the shares redeemed must be transferred to an undistributable reserve, namely the capital redemption reserve. And this is the part that my learned friend didn't take you to. In other words, capital is not reduced, but is replaced and maintained either by the new share capital or by the Capital Redemption Reserve Fund. And then there's a rather important footnote, footnote 2, but see paragraph 22 below. Paragraph 22 below is talking about possible exemptions and extensions to the law. And dealing with private companies, Professor Gower talks about possibility A, expressly permit private companies to issue redeemable equity shares. And he refers to the desirability of that. Then at paragraph 22, the other desirable amendment is of greater importance. Anomalously, Section 58 at present permits a premium payable on redemption to be provided either out of profits or out of the share premium account, as does Section 56(2). And the Capital Redemption Reserve Fund, which has to be established, consists only of a sum equal to the nominal amount of the shares redeemed. The result is that capital, in the sense of share capital plus share premium account, need not be fully maintained on redemption. If 1,000 redeemable preference shares of £1 each are issued at £1.10, share capital plus share premium account will equal £1,100. If later the shares are redeemed at £1.20, out of profits and the share premium account, all that will replace the 1,100 is a capital redemption reserve fund of 1,000. This anomaly may not matter much in the case of preference shares in the strict sense, where the premiums are likely to be small. In relation to redeemable equity shares, the premiums might well be many times the nominal value, resulting in a substantial reduction of capital on redemption. It's therefore suggested that sections 56 and 58 should be amended so as to prevent redeemable shares from being redeemed otherwise than out of profits or an issue of new capital without any use of share premium account, which would be left intact. Now, what happened then in the United Kingdom was that the 1981 Act permitted redemptions and purchase of shares other than redeemable shares. In other words, equity shares, which would carry or may carry a substantial premium, could now be redeemed. But the provision that previously allowed share premium account to be used for paying the premium on redemption of shares, debentures, was deleted. And equally, the requirement that the premium payable on redemption could be funded out of profit or share premium account was reduced to requiring it to be funded out of profits. As we'll see, when Cayman lifted the lid on redemptions to apply not simply to redeemable preference shares, but to equity shares as well, no equivalent deletion was made in respect of share premium account. So that which Professor Gower was talking about, the reduction of capital inherent, if one regards capital as including share premium account, the reduction of capital inherent in the payment of a premium on a redemption funded out of share premium account applied with full rigour in Cayman, whereas that possibility had been eliminated in the UK.
Can you just remind me, which is the provision which gives effect to Professor Gower's suggestion there?
That's the 1981 Act, and I think we have that in Bundle 1. It's an insert because the previous this is a late insert, I'm afraid. The bundle previously had 2 copies of the 1985 provisions. Now,
Thank you.
yes.
It was meant to be tab 9.
Meant to be tab 9.
Oh, thank you.
Oh, thank you.
Now, you can see here, I hope, power to issue redeemable shares, section 45 of the Act. The company can issue shares which are liable to be redeemed. You'll see it's no longer preference shares. There are still the conditions at 2, which has come in, sorry, the condition at 2 is a new one because now all shares are potentially redeemable, so we've got to make sure there are some that aren't. Redeemable shares not be redeemed till they're fully paid. Terms of redemption must provide for payment on redemption. That's the provision that I was referring to earlier, and as you'll see, Cayman never adopted that provision either.
Where's that?
That's
45.
paragraph 45, subsection 4.
4, rather.
45.3.
No, 4, sorry.
And
So
then,
where's the provision which enables you to continue to use the share premium account on...
well, you can't use it. That's the point.
yes, you can't, sorry. Yes,
You can't. Subject to subsection 6.
Right, where's that?
It's 5A.
It's 5A which says you can't, effectively, yes.
Well, no, 5A is the same as it was before. Redeemable shares are only redeemed on distributable profits.
Which 5B? It's 5B. 5B.
Yes.
And
Yeah.
Yes, I see.
So it says B, which is not be produced in Cayman, is that the point?
well, B in Cayman still says or share premium account.
Yeah.
It's the elimination, the change here was that the 1948 Act said the premium must be paid out of distributable profits or share premium account. The 1981 Act repealed those sections of the 1948 Act. And in consequence, the premium must be paid out of distributable profits.
I'm sorry, and that is to meet the point that Professor Gower made.
Meet Professor Gower's point. Now, I have, it's not in here, I'm afraid. I didn't put this together, and it's not in here. And we can let you have the reference later, but if for the moment you take it from me that the 1981 Act in Schedule 4 provided for an amendment to the provisions, I think, of Section 56 of the 48 Act by deleting the words that the share premium account could be used for payment of premiums on redemption of shares. You only get that from the amendment in Schedule 4 of the 81 Act. And I'm afraid I hadn't flagged that. Repeals. Yeah. Yes, it's Schedule 4 of the 81 Act and the Companies Act 1948 Act, extent of repeal in Section 54. So if we can open Section 54 of the 48 Act, which is no, sorry, it's Section 56.
Yes, it's 56.
Section 56. In Section 56(2), delete the words from of it.
I'm getting completely lost. We're now on...
These are the words which are deleted by Schedule 4.
It's the last 3 lines of subsection 2 on page 594.
Yeah. They're deleted by...
All providing.
They're deleted.
They're deleted by Schedule 4, yes.
Is that where they're deleted by a provision which we don't have?
Yes, but we can get those.
Could this be put in a note form?
We can do that.
With the relevant provision attached?
Yes. Now, Cayman didn't follow that. Just before getting there, and while remaining on the existing language of the previous language in respect of redemption of shares, you'll see how Professor Gower gave his example and referred to the reduction in share premium as being a reduction of capital. I think my lords have already picked this up with my learned friend, but his conclusion that the subsections, the requirement to redeem out of profits and then to provide for the redemption out of profits or share premium, my learned friend says is cumulative. I think my lords have already picked him up on this, effectively, that if you must provide premium both out of share premium account and pay it out of profits, in other words, if the redemption provision covers redemption and premium, it's probably easier to go to the authority itself. If we work from the 63 one that we were in Cayman at tab 1, and we look at section 34.
Sorry, where are we going? Which tab?
Tab 1,
Yep.
section 34. And we're considering subsection A
Yep.
and subsection C. The question is whether those are separate or cumulative requirements.
Well, this is preference shares, so that
These are still preference shares, yes.
so we're likely to be talking about something which has a substantial nominal value and might be a small premium.
And
Yeah.
might be a small
Okay.
premium.
So you say they start with separately by A and C.
So we say that those are separate provisions and that you don't need to double up. If you provide for the premium out of share premium account, you don't also need to pay it out of profits under A.
Not even clear what that would mean, but
Well, my Lord, I hope that's
yes.
I hope that's clear.
Well, it's not to me with respect, but
Well,
perhaps if you can put it in a note, it may.
well, we can certainly do that.
But your point is, isn't it, that A is talking about the nominal value of the preference shares, which will be substantial, and C is catering for the possibility of the sum premium, it's only the premium which can be provided out of either profits or the share premium account, whereas the nominal value must be provided out of profits or proceeds of fresh issue.
Proceeds of fresh issue.
So they're different routes, and to treat A as including C and imposing an additional requirement in respect of the any premium is wrong, you say. And
Well, it's wrong, and it must be wrong, because otherwise you having provided for the premium to be paid out of share premium account,
you then have to provide that it's paid out of profits. You have to find some further profits. So you have
double it up, and you then have this loose provision that you'd already provided for out of share premium, then hanging around in your balance sheet.
Yeah.
So that's what we say about that. When we get then to the 2007 Companies Law, bring us up to date, my learned friend did that via the 87 and the 89 provision. And I've no particular concerns with the way in which my learned friend dealt with those. It's safe to say that in terms of the policy of the Act, the policy which in the United Kingdom had required the premium be paid out of profits in the case of the redemption of equity shares was not followed in Cayman. And that is a clear and important distinction between the Cayman and the English jurisdictions. I'm going to take it from the 2007 Act because I don't think we need to, as I say, I don't think we need to look at the old ones, but of course it was 1987 was the point at which Cayman opened up the redemption of shares other than preference shares. And one can see that in doing that, at that time, there was no corresponding change, as there had been in England, as regards the restrictions on the use of the share premium account.
Yes, 34.3E
Remained
preserved what the 1981 Act removed in England.
That's right. That's right.
In substance, yes.
In substance. And so when we get to the 2007 Act, which is the one we actually have to construe, what we see is an unbroken line of statutory permission to use share premium for paying the premium on the redemption of shares, notwithstanding that that premium in economic terms may now be very substantial and indeed may be many times the nominal value of the shares which are going to be redeemed. So the reduction of capital insofar as share premium is treated as capital, as I say, it's important to note at common law it isn't capital, but the reduction of capital which Professor Gower was concerned about, saying, well, for policy reasons we have to treat share premium as if it is capital, to that extent, that concern was not a concern in Cayman, so far as the redemption of shares was concerned. Now, it's true.
It says by the insertion as a quid pro quo of the solvency test.
Well,
which came in at the same, as I think I understand it, at the same time.
My Lord,
in subsection...
in the 1987 Act. But that, if I may say so, turns on the points that we have to come to, which is whether that provided an additional route to use share premium for the purpose of paying the nominal amount of the shares, or whether share premium can only be used subject to solvency requirement. What's at issue here?
Where does it come in? Can we just identify where it comes in 1987, is it?
It comes in two...
Oh.
Sorry, it comes in 1987. It's at tab 2.
Yeah.
And we carry on, we can pick it up at 555F. You'll see the substitution to section 34 of the principal law.
(34.6a) is it? 555I.
Yes. So what we have is a provision that now allows you to issue any shares which might be redeemed. It's then subject to the same conditions at subsection 3. Subsection 3E continues to provide, as it always did, that the premium payable on redemption or purchase must be provided out of profits or out of share premium account before at the same time the shares are redeemed. Exactly the same statutory language. So that permission is still there. The permission in the share premium account provisions haven't changed. And then F says, subject to the provisions of subsection 5, shares may only be redeemed or purchased out of profits. Now, of course, the question of construction that this panel has to deal with on the 2007 Act arises in relation to the different strands of permissions and requirements which are given by these sections. And that's what we have to address. But in terms of the history, the permission to use share premium account for paying premiums on shares has remained throughout. And that notwithstanding the opening up of redeemable shares to equity shares. Now, the question of whether that came with the quid pro quo of share premium account being used only subject to a solvency requirement is something that we'll have to address. And that's obviously at the heart of the issue. And that's going to be a question of construction. But if one looks at the policy of that, we can look at how the Cayman court has addressed, the Cayman legislature has addressed the issue subsequently as well. My learned friend says, of course, that the Court of Appeals fell into error by looking at the 2011 Act. And it may be not uninteresting to look at the 2011 Act to see whether there is a constant stream of permission running through Cayman legislation as to the use of share premium for paying premia on the redemption of shares without a solvency requirement, or whether there was simply a little blip between 1987 and 2011, that there was some policy ground which raised its head during that period and then somehow mysteriously went away. But we can look at that in more general policy terms. Lords, would that be a convenient note?
You're doing quite well, are you?
Yes.
We'll resume at 2 o'clock.
Are you going to sit on?
Yes, we did. I suspect you're not going to finish today, but how long do you envisage each of you on the other issue?
3/4 of an hour to an hour.
I see. And
Half to 3/4 of an hour.
an hour and a half. And how much longer have you got on this issue? You've probably got quite a bit.
About an hour.
Yes. I think we're unlikely to finish today, and we probably won't need to sit late.
Strike as well.
Right.